Hello everyone and welcome to today's webinar on Advanced Care Planning, the Medico-legal elements. I'm Dr Karen Detering from Advanced Care Planning Australia, and with me today I have Dr Jane Deacon from MDA National. I'd like to open this webinar with an announcement of acknowledgement of country. So I'd like to acknowledge that we're all on Aboriginal land and to pay our respects to elders past and present from across the country. I'd also like to acknowledge any Aboriginal people that are joining us here today. So what I'd like to do now is to introduce Jane Deacon. So Jane is a general practitioner from Perth, and she's worked in general practice for a long time and has been a practice principal. She's started at MDA National approximately 11 years ago and is one of the medico-legal advisors. So Jane, welcome and thank you for coming and joining us today on the webinar.
Thank you for asking me.
Today, what we're going to do with our webinar, so the webinar is going to run for approximately 30 minutes or so, and we're going to go through some slides with some information relevant to advanced care planning and how it can be put into practice. And along the way, we're going to use a case study to illustrate some of the components as well. So let's get going. So over to you, Jane.
Right. Well, our presentation today, we're going to cover some definitions, which I think is even more important than usual in this situation because of the very confusing names that the same things have right around the states. Each state has their own legislation in this area and they often use different words for the same thing. Then we're going to talk about a case study, which I hope will bring this to life, and we'll have some real-world examples around that. And then some resources where you can get further information both for doctors and also for your patients and their families who might want to read some more about what's involved in advanced care planning. Advanced care planning is the overarching term referring to a process where a person can plan for their future health and personal care, taking into account a person's values, beliefs and preferences, so that they can guide decision making at a future time when that person either cannot make decisions or they cannot communicate his or her decisions. An advanced care directive is a type of written advanced care plan which is recognised by common law or specific legislation in that particular state. And this document should be completed and signed by a competent adult. Advanced Care Directive is called several different things, Advanced Health Directive or Advanced Care Directive, depending on where you are. And it records the person's preferences for future care. A person can also appoint a substitute decision maker to make decisions about health care and personal life management in the future, and we're going to talk more about that. There's Advanced Care Directive legislation in every state and territory except New South Wales and Tasmania. But in both New South Wales and Tasmania, the health departments do encourage their use, and there is some case law from New South Wales where an advanced care directive was upheld even though there is no specific legislation there. So they can still be used in New South Wales and Tasmania.
So Jane, does that mean that a person should actually write their preferences down in an advanced care directive in one of the statutory documents? Is that what you would be recommending?
Well, I think the first thing is communication. Okay. And this is where doctors can be really helpful in initiating that discussion with their patient and encouraging their patient to talk to their family about what their preferences are. I think an advanced care directive is very helpful in some situations. So if a person, for instance, has something specific that they would never want, and I'm thinking about Jehovah's Witness and blood products, then I think an advanced care directive is very appropriate in that situation. And similarly, if the person is at the beginning of a disease that has a known projection and they know what's going to happen and they have strong preferences about the kind of care they would like when they no longer have capacity or can no longer communicate those decisions, I think that can be helpful as well. But Otherwise, it's not essential that people have an advanced care directive. I think communicating with their family is the most important thing, and having that discussion.
So, Jane, in my experience, I've had people write down a values type directive, or where people have written down their goals and their values and maybe the outcomes they're trying to achieve. Have you had experience along those lines, and have you found that helpful as well?
Yes, I think that's very helpful for people to discuss in general terms that they, for instance, don't want heroics at the end of their life. They'd like to go peacefully when there's no reasonable prospect of them regaining capacity and having some quality of life afterwards, or whatever the situation is. And the GP can make some notes about that, and again encourage the patient to talk to their family about it.
Yeah, no, that sounds great. And presumably if somebody is going to write down their preferences in some sort of document, or the GP is going to write the information down on behalf of the person, then making sure that it's available for the hospital or for their aged care facility or wherever they are, I'm assuming would make things really great and easier for everybody.
It would. At the moment there's no standardised place to keep that, but perhaps with the My Health record, that would be an obvious place to store documents like that. Yeah,
it does seem really obvious, and I know there's quite a bit of work going on in Australia to try and support that happening, but clearly it's still a work in progress. So not having legislation specific legislation in New South Wales and Tasmania isn't necessarily a huge hindrance for people in those states doing advanced care planning, is it?
No, they can still prepare a document outlining what their thoughts are and what treatment they would or wouldn't want to have at the end of their life.
Yeah, so it comes back very much to the previous slide, and that it's really a process of communication, and I guess the advanced care directive component can be the documentation, but there's lots of different ways that this information can be written down.
Yes, and the advanced care directive forms in the states which do have legislation are all a bit different and have some sort of nuances, so you can complete the one that's relevant for your state.
Great.
Just a little bit about capacity now. So all adults are presumed to have capacity, and this means the ability to understand and appreciate information about one's health and the options for treatment, including no treatment. To make an advanced care directive, it should be a free and voluntary decision about one's health, and the person must be able to communicate that decision in some way. Some states do allow for a person to sign on behalf of the person making the advanced care directive. And assessment of capacity is decision specific. It's not an all or none type thing, and it does depend on the complexity of the decision. So you might get someone who is able to make a decision about some sorts of treatment for themselves if the treatment is fairly straightforward, but in more complex situations where they're weighing up maybe some complex care regarding a cancer treatment, they may not have the capacity to make that decision and would need some assistance with that. The substitute decision maker. This is a person appointed or authorised by law to make substitute decisions on behalf of a person who no longer has the capacity to make decisions about their medical care. This is a very confusing area naming-wise, as there's about 6 different terms that are used around Australia for this, including a guardian, an attorney for health matters, a substitute decision maker, a person responsible. There's all sorts of names, but they are essentially the same, the person who makes decisions on behalf of a person who can't. A substitute decision maker can be appointed by the person when they have capacity, and that is often called an enduring guardian or whatever. They can be appointed for or on behalf of the person, or if there's no guardian appointed, then they are identified as the default decision maker by the Tribunal or Guardianship Act in each state. Interestingly, there is a different hierarchy, or there are some differences in the hierarchy of appropriate decision makers in each state and territory law. And the responsibilities of that substitute decision maker is to make the decision that the person would make if they were now able to. So it's as if they step into the patient's shoes and make the decision that they believe that person would have made. So again, it comes back to the communication of what that person would have wanted, and hopefully they've had some of those discussions with their family, so whoever is making those decisions has some idea about what they would want. And the decision should be in the best interests of the person.
Okay. And I guess it is a little bit confusing that there is the variation throughout Australia, but broadly speaking, I guess there are a lot of similarities as well in terms of being able to appoint somebody.
Yes.
But there's also mechanisms to have somebody appointed for them, or to identify somebody if there isn't an appointment. So I guess all of us need to be really familiar with the laws in our jurisdiction. And fortunately, there are a lot of resources around to help that, including the Advanced Care Planning Australia website has jurisdiction-specific information. So to try and make it just that little bit easier for everyone, but it would be nice if there was uniform laws as well.
Yes. Futile care is treatment that no longer provides a benefit to a patient, or treatment where the burdens of treatment outweigh the benefits. And doctors are not obliged to provide futile care, but this can sometimes lead to difficulties if there are family members, for instance, who want care which the doctors believe is futile. And there are some mechanisms in place for trying to resolve that situation.
Yeah, and I guess I find that futile care can be a little confusing sometimes for doctors to work through, in terms of, I guess the definition sort of tells us what it is, but in practice I think trying to truly work out for an individual person whether the care that might be on offer is likely to be of benefit to the person, or whether it truly is futile care. And I've certainly found in this sort of situation that understanding a person's values and potentially what they're hoping to achieve by treatment can be really helpful in trying to determine whether the care would potentially be of benefit, or whether perhaps the person wouldn't have wanted that treatment because it wouldn't meet their expectations in terms of outcome.
Yes. So look, these can be difficult discussions, and I think it's important if the doctors have got a clear idea about what are the likely benefits and burdens of treatments that are available, and then they sit down and speak with family members, speak with the decision maker, however they've come about, whether it's guardian or family members or whatever, so that everyone can hopefully reach a consensus about what is going to be the best way forward, and if the treatment is, as the doctors believe, futile, if the family then accept that there's no benefit to continuing treatment.
Look, and I think that all makes a lot of sense, and I like the idea of potentially first having a discussion to try and get the treating teams on the same page, so that they all understand what it is they're trying to achieve, understanding, of course, that there's always going to be some differences in opinion, but I think it's certainly helpful if the treating teams can be broadly on the same page, and then trying to have discussions with patients and more than likely family members to try and work out what is the best thing to do in often what is clearly very difficult circumstances.
Yes.
So over to Mrs. Smith.
Mrs. Smith, one of your elderly patients, 84 years of age, with a number of ongoing chronic health problems, COPD, ischemic heart disease, some renal failure. Now, she's recently been diagnosed with dementia, but is in the early stages and still has capacity. You know that she's a widow living on her own, and you're aware that a daughter lives nearby and is helpful to her mum, and you have some awareness of an estranged son. So I think this is a good opportunity if Mrs. Smith has come in, for instance, after her diagnosis of dementia, or perhaps she's come in for some routine medications, for you to raise the topic of what sort of care she would like in the future, if or when she loses capacity. And I think a lot of elderly people have thought about this, perhaps in the middle of the night, but may not know how to raise it with their GP. So I think a lot of people will welcome that discussion, and I think it is a really important discussion to have. Triggers for that discussion could be, as in this case, a new and serious diagnosis, or it could be as part of the over 75 health check, where I think it follows on quite nicely from your inquiries about where the patient lives and who makes their meals and have they thought about future care, to have that discussion with them and get the communication going. Also, if the patient changes residence, they're moving into a retirement village or a nursing home, or their daughter's granny flat, that can be another trigger to think about their changed circumstances and ask them about their future thoughts. I also encourage doctors with an elderly person to ask them if they have consent to communicate with a trusted family member about their health care. And that can be really useful. Then you know if it's a complex decision, there's someone else besides the patient that you can talk to. Or if you're in that situation where you can't get a hold of the patient with some urgent results, you know that you can phone the daughter on her mobile and she'll answer and help you to find her mum.
Actually, I think that last point is really interesting, and I know it's encouraged in practice to try and to support somebody in making their own decisions. And in the new Victorian legislation that is enacted in March of 2018, there is actually written into the legislation a support person, which is essentially filling that role. So the support person can access information on behalf of a patient to then help the patient make their decision. So really supporting them to actually be involved as much as possible in decision making.
Yeah, I think that's really helpful and really good for GPs to have that assistance with their patients. So in this case, you talk to Mrs. Smith about this, and she goes off and talks to her daughter, and then she comes back to the practice with her daughter, and they ask you to witness an enduring power of attorney for medical treatment form. So you're pretty comfortable with that decision, even though Mrs. Smith is in the early stages of dementia. You're feeling confident that she's made that decision, that she has the capacity to make that decision. The term enduring power of attorney, which is for medical treatment, which is used in some states, is particularly confusing because there's also the enduring power of attorney, which usually means someone who makes financial decisions for a person when they lose capacity. So there are those two different roles, the enduring attorney and the enduring guardian, which is another name for it, which may or may not be the same person.
Yeah, it's a little. The terminology is quite confusing, isn't it? And I think then trying to describe what the person's role is can be really helpful. And I think I've certainly found, partly I think because the terminology is confusing, and maybe for other reasons, that people do get a little bit confused in terms of if they have made an appointment, exactly what that person is going to do. And when you think of it from a person's perspective, they often are viewing it that maybe the same person might make a few different decisions, and we just need to make sure that we help people through the various processes. And obviously some of them are a bit more medically focused and some of them might be a bit more legally focused, but if we work together, hopefully we can support our patients to actually complete the relevant documents they need to. But it can be a bit confusing.
Yes. So the next thing that happens is you receive a letter from the son's solicitor seeking a copy of his mother's medical record. And at MDA National we get quite a few calls from people seeking copies of the medical records. And there's sometimes a bit of confusion about who can access those records. So in this case, if Mrs. Smith still has capacity, perhaps it's at the early stage of her illness, she may have capacity to answer that question, and you have to ask her whether you can send a copy of her medical records to her son's solicitor. It's not a very complex decision, so she may well have capacity to talk about that. If we were further down the track and she had lost capacity to a great extent, she might not be able to answer that question, in which case you would go to the enduring power of attorney for medical treatment, that's her daughter, and you would ask her daughter about whether you could release the notes. If whoever says no, then you have to write back to the solicitor to say, sorry, we don't have appropriate consent to release those records.
So it's interesting, isn't it, really, in terms of this? Because I think as a doctor, when we get a letter from a lawyer, we think we have to comply with it. So I think it's really interesting to actually think about what's in the letter and what is our duty of care to our patients, and what is the legislation around what we actually need to do. And I think many of us would probably go and ask a competent patient, but may not always think about it beyond that. So really great information.
Yes, I think doctors often think that if the lawyer asks for it, they're entitled to it, but that's not the case.
So Jane, can anybody be an appointed substitute decision maker?
Well, the legislation is consistent in that the person should be over the age of 18 years, but there are some differences between states beyond that. Some states specify that the guardian should have legal capacity, which would be helpful. And some state legislation states that the appointed person should not be the paid carer or the doctor of the patient. And we would counsel any doctor, even if it is allowed in that particular state, against being the appointed guardian or enduring power of attorney for their patient, because that is a conflict of roles and potentially there are some difficulties. And I know doctors do get asked from time to time, and for the patient it might seem like an obvious choice, but it's not a wise idea. So Mrs. Smith, she's admitted to hospital sometime later with sepsis and exacerbation of her renal failure, discharged to a nursing home, and the discharge summary states no further treatment available for her deteriorating renal disease. Her mental abilities have really gone downhill, and she no longer has any capacity to make health decisions for herself. So you've got Mrs. Smith in the nursing home, and you now receive another letter from the Sun solicitor saying that the patient must be provided with active treatment, including CPR and admission to hospital if her condition deteriorates. The patient's daughter contacts you and asks you to increase the sedatives to decrease her mother's suffering. So
conflict.
A conflict, yes.
So what would you do in that situation, Jane?
Well, the letter of the law would say you go with the decision of the enduring power of attorney for health decisions. However, I think first of all you'd try to have some communication with the son, with the daughter's consent, to try to bring him up to speed about what has been happening to his mum, what is her current condition and prognosis and the burden of treatment, to try to get him to see the situation as it is. If he's been estranged from his mum, perhaps he doesn't really realise how much he's deteriorated. And would be very helpful in the ideal situation to get him round to the point of view of the daughter and you and the hospital doctors, so that there's not a split between him and his sister. But at the end of the day, you're going to have to go with the daughter's decision, which is the correct one.
Okay. And I guess in Mrs. Smith's situation, she's also obviously deteriorating, and I'm imagining that most doctors would be very much on the side of the daughter as well, in terms of if what the son is actually requesting would be deemed to be futile treatment, yes, for Margaret Smith. So yes, there would be no obligation to actually provide that treatment in Mrs. Smith's situation.
Yes, as a matter of fact, we had a call a while ago from a similar situation with a mum who'd lost capacity, and she had two sons. One wanted active treatment and everything done, and the other son wanted comfort care. And there was no one had been appointed as the decision maker. So following the hierarchy, it came down to adult children, and in WA it doesn't say which child, it just says children. So the GP rang for some advice about how to handle this situation. And after some discussion, the son who wanted active treatment had taken a dislike to the GP, and they weren't communicating very well at that point. It was decided that they would get a second opinion. And in the town where they lived, there was no geriatrician all the time. There was a visiting geriatrician. But they decided to ask an older, more experienced GP who hadn't been involved in the patient's care. And there was a meeting between that GP and the two sons, and it was very fruitful, and they were able to come to some consensus about treatment, and then it could proceed. If they hadn't been able to reach a decision, then it may have had to go to the tribunal in that state for either appointment of a guardian or a treatment decision.
So based on some of the conversation that we've just been having, clearly encouraging people to do advanced care planning whilst they're able to, even if it's simply having a discussion with the key people that are likely to be involved in the decisions and potentially writing down some of the wishes if there is likely to be a dispute would be incredibly helpful, wouldn't it?
Yes, very helpful. If that patient with the warring sons had made a document and written down what she wanted in the future, that would have been very helpful to the sons.
Yeah, it's a pity that we don't always get what we need, but certainly, and I'm sure the person themselves would have not wanted the situation that subsequently transpired with the sons, and I guess it's all very hard sometimes, isn't it? But advanced care planning can help.
Yes. I think it's sometimes a shock when the child from out of town arrives to find that their parent has deteriorated, and they're struggling with those feelings as well as some hard decisions.
Yeah, it must be really hard, and I guess grief and deterioration and nearing death brings out the worst in everyone often. So, yeah. Okay, so back to Mrs. Smith.
So you discuss the ongoing treatment plan with the renal physician, you document that plan, and you proceed with providing care for Mrs. Smith to keep her comfortable but not active treatment. And your patient dies in the nursing home while you're on annual leave, and one of your GP colleagues completes the death certificate. I think we mentioned this because this is a question we get at MDA not infrequently. Can you write a death certificate for a patient you've never seen? And the answer is, under some circumstances, yes. So if your GP colleague has access to all the notes, maybe you've spoken to your GP colleague before you went on annual leave to say, a bit worried about Mrs. Smith, she might die while I'm away, then your colleague can complete the death certificate. If you are in any doubt about whether you can complete a death certificate or need to report a death to the coroner, then you can ring the coroner's office in your state to get some guidance on that, and they're usually very helpful. But in this kind of situation, they're going to tell you to complete the death certificate. The death certificate records dementia with no time frame listed. And I'd just like to say, if you put dementia on the death certificate, always put approximately the time it started, because dementia on a death certificate is going to lead to some difficulties potentially with a probate depending on the date of the will, and you're going to get some letters from lawyers and all sorts of things. So try to put a time frame there.
Good advice.
So in summary, an adult patient can refuse medical treatment at any time for whatever reason, and they can refuse treatment through an advanced care directive which can operate when their capacity is lost, even if this results in their death. Advanced care planning and/or an advanced care directive can assist when the patient loses capacity, but decisions to withhold and withdraw life-sustaining medical treatment can be complex, involving family members. It's a very emotional topic. And if you are having difficulties with any of this, you should seek advice from your medical defence organisation. And if there's any doubt about whether the advanced care directive is valid or not, then you can seek advice from the courts. And remember, doctors do not have to comply with requests for futile treatment, either from the patient or the patient's family. and do not have to provide and shouldn't provide clinically inappropriate treatment. But again, I'd say seek advice if you're unsure how to proceed, either from your medical defence organisation or the legal department in your hospital.
And I guess the other place that we would often seek advice is from colleagues within our team, or potentially a second opinion is a great way forward, particularly if there's likely to be conflict or maybe we don't actually know what to do and we need some help.
Yes, I think that's really important, that doctors have consulted widely, if necessary, getting in a psychiatrist or a geriatrician or people from other departments to give an opinion when they haven't been involved in the ongoing care of the patient.
So what we've really been talking about today is that we can actually do advanced care planning in all jurisdictions in Australia, even though the nuances vary a little bit, and maybe the form we need to fill in or what the form's called or what the person's called varies a little bit. But throughout all jurisdictions in Australia, it's possible to legally appoint a substitute decision maker to make medical decisions on behalf of a person that lacks capacity, and also for somebody with capacity to actually write down ahead of time their preferences, either as a more values or outcome based document or a more specific treatment focused or instructional type document. So except in New South Wales and Tasmania where you can't do the latter.
Well, you can still write things down, but you don't need to use the prescribed form. There isn't a prescribed form.
Well, there isn't a prescribed form, but there's lots of things that can be done. And I think, as you've also pointed out, general practice is well placed to be supporting people with advanced care planning, and because of the relationships that general practitioners often have with patients over long periods of time, but also there's lots of triggers like some of the ones that you mentioned, which can be really helpful, particularly to support people to do advanced care planning over a period of time, because it's not just one conversation, but hopefully a conversation that occurs over time and will be updated as there's significant changes in a person's clinical state.
Yes.
Yeah. So that's fantastic. So fortunately, there are a lot of resources. You can see the resources there that are listed. So there's resources through the Advanced Care Planning Australia website, including some legal resources for your particular jurisdictions. We also have an Advanced Care Planning Advisory Service that patients, people, carers and health professionals can ring to seek advice. So that runs during business hours, Eastern Daylight Time. And for people ringing through to the advisory service, what the staff that are answering the advisory service do is try and link people back into their local care networks and local jurisdictions and local information. There's also advanced care planning fact sheets on the HealthShare digital platform, and there's ACP learning that can be linked in through the Advanced Care Planning Australia website. So at the moment there's 7 active modules with some more modules coming, and there's also a lot of other resources for people in case they want to run workshops or other things, potentially in their practice or in their state or whatever. There's also educational materials available through Think GP, including one specifically for advanced care planning. And then there's also a lot of resources through the RAC GP website as well, and these resources are also constantly getting updated. So I think we're in a great situation where there's a lot of resources available to help and support that, but we're also happy at Advanced Care Planning Australia, if anyone has questions about how to get resources or information, we're happy to take those calls, and obviously through the various other medical defence associations, legal departments and the Office of Public Advocates in each of the states are really, really helpful as well if there's any questions. So thank you everyone. It's been great to be part of this webinar today, and hopefully you've gained something out of this. So thank you very much for joining us here today, and thank you Jane for being part of this webinar and sharing your expertise. So thank you.
You're welcome.